This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why an agreement to settle a workers' compensation claim does not compel payment by an insurer for intentional acts against the employee, and why insurance should never, ever apply to indemnify an insured against its intentional acts, because intentional acts are and should always be excluded. And even if they're not, an intentional act can never be fortuitous, so that therefore the claim of intentional acts are simply not insurable. Sylvia Melania Tejada de Tapia was injured at work and filed a workers' compensation claim against her employer, 74 Industries, Inc., which was settled pursuant to an order approving settlement with dismissal under statute called the Section 20 settlement, which resulted in the dismissal of plaintiff's workers' compensation claims with prejudice. Workers' compensation, of course, is an exclusive remedy for an employee injured at work without fault. In Sylvia de Tapia versus 74 Industries and Velcro USA, Inc. et al. Versus New Jersey Manufacturers Insurance Company, a decision of the Superior Court of New Jersey Appellate Division, on July 12, 2024, the Appellate Division explained why workers' compensation settlements have no effect or should have no effect on tort law. Plaintiff suffered an injury after she was bitten or stung by an insect during the course of her employment as a sewing machine operator with 74 Industries. According to plaintiff, insects routinely infested the packages of fabric and materials that employees handled and frequently bit and stung employees. Plaintiff was hospitalized for treatment related to the infection she suffered as a result of the insect bite. The infection caused her right leg to swell and form green, open sores. New Jersey Manufacturers Insurance Company had issued a standard workers' compensation insurance policy to 74 Industries and recommended settlement of plaintiff's workers' compensation claim, and prior to the settlement, however, plaintiff had also filed a complaint in the Law Division alleging intentional torts against 74 Industries. 74 Industries filed a third-party claim against NJM, seeking coverage under the policy for plaintiff's claims of intentional wrong asserted against them. NJM denied coverage, citing policy exclusions for intentional torts, and moved to dismiss 74 Industries' third-party complaint for failure to state a claim. NJM defended 74 Industries in workers' compensation court and eventually recommended 74 Industries settle plaintiff's case for a lump sum payment of $25,000 by way of an order approving settlement with dismissal of the workers' comp claim. Prior to the entry of the Section 20 settlement, however, plaintiff filed an action in the Law Division alleging her injuries were caused by 74 Industries' intentional misconduct under the principles explained by the court in a prior decision. Plaintiff had filed a series of amended complaints, each of which included the same 4 counts against 74 Industries. The court further found that plaintiff's allegations fell squarely within the policy's exclusion for intentional wrongs and rejected 74 Industries' contention that the policies were ambiguous because the exclusion endorsement provided coverage for bodily injuries under Part 2 of the policy. The interpretation of an insurance policy, like any contract, is a question of law, and in attempting to discern the meaning of a provision in an insurance contract, the plain language is ordinarily the most direct route. The plain and unambiguous language in the endorsement clearly covers plaintiff's intentional tort claims that result from a subjective intent to injure, and those that are substantially certain to have caused injury. As the motion court acknowledged, plaintiff asserts that she was threatened with adverse employment action if she left the job site for medical treatment, which, based on a fair reading of the complaint, suggested to the court a cause of action for coercion. Defendants claim that it is entitled to coverage under the exclusion fails because plaintiff's causes of action are founded on intentional wrongs. Lastly, the Appellate Division rejected 74 Industries' argument that public policy supports coverage for intentional wrongs, as New Jersey courts have consistently held that exclusions for intentional wrongs contained in insurance policies are legally valid. Therefore, there was no basis to support 74 Industries' argument that public policy favors coverage for plaintiff's intentional wrongs filed in the Law Division. The court could discern no basis to conclude that NJM had a duty to defend or indemnify 74 Industries against plaintiff's intentional wrong claims made in the Law Division's Fourth Amended Complaint. In my opinion, insurance, by definition, only indemnifies against fortuitous conduct, an accident. Intentional acts like those pleaded by Ms. Tejada de Tapia are not fortuitous, but intentional and not insurable. The insurer, to be safe, added an exclusion for intentional acts, which made clear its position and the requirement of fortuity. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. You'll also gain access to the more than 4,800 blog postings. You can also subscribe to these videos at YouTube and rumble.com, and if you do, I'd appreciate a like button click if you watch on YouTube and a thumbs up button click if you watch on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.